Thank you. Seconded, there is a motion to recommend to the plenary for the commission to give its consent to the nominations and to the confirm the ad interim appointments of 5 officials of the Department of Foreign Affairs, namely Ambassador Marilyn Baha, Chief Mission Class 1 as Ambassador Extraordinary and Plenipotentiary to the Sultanate of Oman. The second person is Ambassador Charmaine Aviculville, Chief Mission Class 2 as Ambassador Extraordinary and Plenipotentiary to the Arab Republic of Egypt with concurrent jurisdictions over the Republic of Djibouti, the State of Eritrea, and the Republic of the Sudan. The Ambassador Myla Grace Makahilig, Chief Mission Class 2 as Ambassador Extraordinary and Plenipotentiary to the Republic of South Africa with concurrent jurisdiction over the Republic of Botswana, Kingdom of Eswatini, Kingdom of Lesotho, Republic of Madagascar, Republic of Mauritius, Republic of Mozambique, Republic of Namibia, Republic of Zambia, and the Republic of Zimbabwe. And to the ad interim appointments of Miguel Carlo Morilla to Foreign Service Officer Class 1, who is in Frankfurt, and Paulo Marco Reche Mapula, Foreign Service Officer Class 2, is in New York. Are there any objections? Hearing none, the nominations and ad interim appointments of the 5 aforementioned officials in the Department of Foreign Affairs are hereby recommended to the plenary session of the Commission and Appointments.
Judicial and Bar Council of the Commission on Appointments in the first regular session of the 20th Congress is hereby called to order. Mr. Secretary, please call the roll.
The honorable officers and members of the Committee on Justice and Judicial and Bar Council. Chairperson, Senator Rodante D. Marcoleta. Vice Chairperson, Representative Jose Joboy S. Aquino II. Members, Representative Romeo M. Acop, Representative Benjamin C. Agarao Jr., Senator Joseph Victor J. V. G. Ejercito, Senator Jinggoy Ejercito Estrada, Representative Arnie B. Fentebella, Senator Christopher Lawrence Bong Tigo, Senator Risa Ontiveros, Senator Panfilo M. Lacson, Senator Manuel Lito M. Lapid, Representative Roy M. Loyola, Senator Imee R. Marcos, Representative Lani Mercado Revilla, Representative Eddie Bong G. Plaza, Senator Rafi T. Tulfo, Senator Mark A. Villar, ex-officio members, Vice Chairperson Ramon N. Guico Jr., Majority Floor Leader, Representative Jordine Jesus M. Romualdo, Assistant Majority Floor Leader, Senator Lauren Ligarda, Assistant Majority Floor Leader, Representative Alfredo A. Garbin Jr., Minority Floor Leader, Senator Joel Villanueva, Assistant Minority Floor Leader, Representative Antonio Tony Petty Albano, Assistant Minority Floor Leader, Representative Alan Yuti.
With 11 members present in person, including the chair and 1 member present online, with a total of 12 members present, the existence of a quorum is hereby declared. Good morning, esteemed members of the Commission on Appointments, distinguished guests, ladies and gentlemen. Today, your committee is tasked to consider the ad interim appointment of Mr. Jose Catral Mendoza as member representing the retired justices of the Supreme Court, Judicial and Bar Council, Supreme Court of the Philippines for a term expiring on 9 July 2029. Good morning, Justice Mendoza. You may take the designated seat in front of you, sir. Mr. Secretary, kindly report on the jurisdictional requirements and other pertinent information relative to the ad interim appointment of Justice Mendoza in compliance with the new rules of the Commission and the rules of the standing committees.
Thank you, Mr. Chair, Your Honors. The ad interim appointment of Mr. Jose Catral Mendoza, dated 18 July 2025, was received by the Commission Secretariat on 24 July 2025 and was referred to the Committee on Justice and Judicial and Bar Council on 26 August 2025 pursuant to Section 16, Chapter 5 of the new rules of the Commission. His ad interim appointment was published in two newspapers of general circulation, namely Manila Standard and Malaya Business Insight on 31 July 2025 and broadcast over PTV4 at 6:45 p.m. on the same date pursuant to Section 2, Article 2 of the Rules of the Standing Committees. The appointee had complied with the submission of the mandatory documentary requirements on 20 August 2025 as provided for in Section 24, Chapter 6 of the Rules of the Commission. Lastly, the Commission Secretariat has not received any opposition against his ad interim appointment. That is all, Mr. Chair, Your Honors.
Mr. Secretary, please administer the oath to Justice Mendoza.
Justice Mendoza, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this proceeding, so help you God?
Yes, Your Honor.
Mr. Chair, Justice Mendoza is now under oath.
Justice Mendoza, sir, you may give your opening statement if you have any.
Good morning, Your Honors. I am Jose Catral Mendoza, a retired Justice of the Supreme Court. On October 25, 2017, I was appointed by the President as member of the Judicial and Bar Council, representing the retired justices of the Supreme Court on an ad interim basis. My first term expired on July 9, 2021. On the same day, I was reappointed to the same position. On July 18, 2025, after the expiration of my term this year, I was again reappointed. So this is my third term, if confirmed by your body. As in the case of my first two appointments, my latest reappointment is subject to the confirmation of this body, the Commission on Appointments. Hence my presence here. I believe that I have the necessary qualifications and experience for the position to which I have been reappointed. Primarily, before my original appointment for the JBC in 2017, I served the judiciary for 36 years. 8 years as a research attorney in both the Court of Appeals and later in the Supreme Court. 15 years as a regional trial court judge. 6 years as a Court of Appeals justice and 7 years and 8 months as a Supreme Court justice. Before that, I was engaged in the practice of law for about 8 years, so I also have the view of an advocate. For the record, I must say that I was trusted and appointed by several presidents. I was first appointed by President Corazon Aquino as RTC Judge of Santa Cruz, Laguna. By President Fidel Ramos as RTC Judge of Quezon City. By President Gloria Macapagal Arroyo as Court of Appeals Justice and as Supreme Court Justice. By President Rodrigo Duterte as JBC member representing the retired justices of the Supreme Court, and by President Ferdinand Marcos Jr. when he reappointed me last July 18, 2025. With my experience as a practitioner, judge, justice, and JBC regular member, I believe I can really help the Judicial and Bar Council in its critical task of selecting for nomination the best and the brightest of the candidates for judicial positions. For members of the judiciary, no less than the Constitution provides that a member of the judiciary must be a person of proven competence, integrity, probity, and independence. I believe I can gauge what a good judicial aspirant is based on his academic and professional record, experience, integrity, impartiality, and judicial temperament. As this is my third term, I can report to this body that as of the latest data, there are a total of 2,893 judicial positions nationwide. Of these, 612 positions are currently vacant, reflecting a 21.15% vacancy rate across the judiciary. Included in this number are 100 vacant positions for judges at large. Of the 612 total vacancies, 348 are published vacancies in both organized and unorganized courts. Among these published vacancies, 151 have been processed by the JBC and now have corresponding shortlist submitted to the President, to the Office of the President. This consists of 145 lower court positions, 2 associate justice positions in the Court of Appeals, and 2 associate justice positions in the Sandigan Bayan. These positions are now simply awaiting presidential action. The remaining 197 published vacancies are still being processed by the JBC. Of these, 165 are lower court positions, currently in the applicant vetting stage, with a total of 883 applicants undergoing evaluation. The other 31 positions pertain to vacant Sharia courts, with Office of the Court Administrator recommendations for opening. Beyond these published vacancies, there are 264 judicial positions that remain unpublished, representing courts that have to be opened for application or nomination. From January to December 2024, the JBC received a total of 2,262 applications for various positions. Of these applicants, 894 were male, while a significantly higher number, 1,368, were female. Meanwhile, among 262 judicial positions appointed during the same period, 108 appointees were male, whereas 154 were female. This appointment distribution further demonstrates that judiciary's commitment to promoting gender balance and empowering more women to serve on the bench, contributing to a more diverse and representative justice system. Thank you very much. That will be my initial statement and report.
Thank you, Mr. Justice. The floor is now open for questioning, if there be any. Senator Marcos.
Yes, Mr. Chair. Thank you very much, Justice, and welcome to the Senate and the Commission on Appointments. My first question is very simple. Is the exercise of the JBC's functions of shortlisting candidates for the judiciary ministerial? Is it merely ministerial, or does it involve judgment and discretion?
Your Honor, it involves judgment and discretion. with respect to the disqualification, there are automatic disqualifications if you have pending cases. But when you meet the criteria and you're not disqualified, then discretion comes in. There are so many factors to be considered by a member in considering an aspirant. Is not only his bar rating, his academic records are also looked into, his experience as a professional, the honors, the awards he garnered, his reputation also, his integrity,
Thank you.
and his record.
Thank you very much, Justice. In other words, the JBC is not a mere rubber stamp. Is that correct? I mean, its job is not merely to ensure that it ticks off all the requirements or deletes in the case of disqualifications. So otherwise, the Constitution wouldn't require such stringent qualifications for one to become a JBC member. Isn't that correct, Paul? Isn't it though before applicants should have already qualified on the last day of the application? I heard this is a practice for regular applicants for the judiciary, the RTC. Why change it for some people? Why does the JBC keep changing its rules? Does the JBC favor someone? Why qualify an applicant on the very last day of final deliberations? I refer to the case of Attorney Logan, who was only issued an ombudsman clearance on October 6, the same day the shortlist was released and sent to the office of the president due to 2 pending ombudsman cases. Why were the rules suddenly changed in her favor?
Actually, Your Honor, when we publish the announcement inviting applicants for we invite the public to report, to comment, to endorse or oppose the applications of those listed applicants. Not all submit their oppositions on time. There are those who submit their clearances when they apply. There are those who reserve or they ask for time to submit their clearances. And after that, there are also oppositions, complaints against the applicants. And in our experience, most of the complaints they're not that serious as to disqualify a candidate. So we consider every opposition. We ask them to comment, to comply with the due process requirement of the Constitution, so they are asked to comment. The last day, because of our experience of complainants or oppositors filing their complaints and opposition during the last week or the last few days of the final deliberation, we deem it unfair if we will automatically disqualify them. So we have to study if the matter is very serious or not.
Yes, Justice, but you made mention of a list of absolute requirements, which contains, among others, a clearance of the ombudsman. Surely that doesn't require an oppositor to file with the JBC. Surely that is of note. Why was Attorney Logan considered, given that the ombudsman clearance was only given on the same day, yesterday, when the shortlist was given? The deadline had long passed. Why is the JBC changing its rules to favor certain people?
It's still within the rules, Your Honor. Before the voting, they should, if they can submit a clearance, they can be qualified and can be
Even on the same day po.
same day.
Because they're given to understand that the required documents are supposed to have been submitted in September, as is usual with regular judges in ordinary courts.
Yes. With respect to judges, we have considered it to be the last day because there are so many good judges.
So there's a distinction po.
When
The
they ask-
ombudsman is special and regular judges have to comply with the rules.
No, they have the same qualification if they have a
But
pending.
there was a deadline for the requirements to be submitted in September,
Oh.
a deadline that was actually extended repeatedly.
Yes. It is on the last day of we call it the final deliberation. If they can submit a clearance, they can be considered. With respect to
Several dates were given po. In
Yes.
September, I recall.
yes, Your Honor.
In any case, did you participate, given that you were reappointed twice? Did you participate in the proceedings in the shortlisting of the ombudsman candidates po?
Yes, yes, Your Honor, because my appointment was ad interim.
So, given the two appointments, you in fact participated. So we are very curious about the occurrences with regard to the JBC shortlisting yesterday. It is very clear that the JBC requires that an applicant should have no pending administrative or criminal case before any office, considering that Secretary Boying Remulla was included in the list of nominees, despite having pending cases and issues touching on propriety. Would you agree that such inclusion may cast doubt on your council's adherence to the constitutional requirement of recognized probity and independence?
We were aware of that. Senator Pangilinan was there, and Congressman Luistro was there when we considered the first issue of whether a candidate is disqualified or not. So in the case of Secretary Remulla, he was able to submit clearances from the ombudsman. And then we checked the JBC rules, and in the JBC rules regarding disqualification, if you have a pending case with the ombudsman, you will be disqualified. But if there is any other administrative case before any other government agency, it will be subject the discretion and evaluation of the individual members. It is only, I do not know why the administrative cases of pending before the ombudsman are different from the other agencies, but that is the rule. And
But surely you're aware that the pending cases were not merely administrative, but in fact criminal. And we can hardly say that recognized probity is in fact upheld.
Mr. Rodder, that is, we are aware of that, but he was able to obtain a clearance. So,
As a matter of fact, some of these cases arose before Secretary Remulla made his intentions known that he intended to become ombudsman. Is this a person of recognized probity? Also, a lifelong politician? Is this a person of recognized independence?
the voting yesterday was in secret, it was confidential. We do not know the members who voted for him and the member who did not vote for him. So, may we ask your indulgence on that? We respect the confidentiality of the JPC proceedings because the Chief Justice, Alexis Mundo, even asked us to execute an undertaking that everything should be confidential for the protection of the members of the JBC, especially the regular members who are not politicians. They are apolitical.
We're certain that you are aware that in 2012, for the position of Chief Justice, two pending disbarments against then Laila de Lima disqualified her.
Before you answer, Justice, the chair would like to acknowledge the presence of Senator Joel Villanueva.
Yes, so this occurred in 2012 when she was disqualified
Yes.
because of two disbarment cases. I am certain that you are aware that there are disbarment cases filed against Secretary Remulla. First, on the 23rd of September, Attorney Topacio filed. Thereafter, on the 2nd of October, acting Davao City Mayor Baste Duterte also filed a disbarment case. In addition, our chairman, Senator Marcoleta, filed his sworn opposition. But in the short list submitted yesterday to the Office of the President, it still included the name of Secretary Remulla. Why is that so, considering that there are two pending disbarment cases and a sworn opposition?
We considered them as complaints, but in our discussion yesterday, it was considered that last-minute oppositions and complaints were considered as mere oppositions by the JBC.
Are you saying, Justice, that all of these cases against Secretary Remulla are entirely baseless?
No, it's still ongoing, but in the minds of the members, there were.
You admit that they were still ongoing, certainly.
Yes,
yes,
Your Honor.
You can hardly say that he is qualified. You yourself said if there are pending cases, and
Yes.
you said that they are ongoing.
Ongoing.
How could you have disregarded them and included him in a short list? You can form your preliminary judgment or opinion on the cases for purposes of JBC proceedings, right?
Yes.
Are we saying that these are baseless? Is it not clear that the case I filed at the Ombudsman was dismissed by the acting Ombudsman Vargas on the sole ground that the Supreme Court would raise prejudicial questions? Certainly, the Ombudsman didn't tackle the merits in any way. Hence, the JBC should have considered it and given it more weight.
Was considered by all the members of the JBC, but we do not know the reasons of each and every member. The JBC,
What were your reasons as a member? How did you justify his inclusion?